Welcome, everyone. This is the Torts workshop for the July 2024 bar exam, and we're going to get right into MBE questions. So I'll start off by sharing my screen, and let's do some Torts questions. An actor straight out of drama school and an agent entered into a one-year contract that described the services the agent would provide. Because he was eager for work, the actor agreed in the contract to pay the agent 15% of his yearly earnings. This is a contract question. Let's just do one contract question for the start of the day. At the end of the year, the actor was so pleased with his many roles that he gave the agent 20% of his earnings. After the first contract had expired, the actor and the agent decided to continue working together. They photocopied their old contract, changed the date, and signed it. At the end of the year, a dispute arose as to what percentage of earnings the actor owed. It is trade practice in the acting profession for actors to pay their agents 10% of their yearly earnings, payable at the end of the year. What percentage of the actor's earnings is a court most likely to award the agent? 20% because the course of dealings is given greater weight than trade usage, 15% because it was an express term of the contract, 10% because the trade usage is the applicable default rule, or nothing because the contract is too indefinite. So starting off with a contracts question just to make sure we're all on our toes.
B, because there's a hierarchy. If I remember correctly, there's a hierarchy. It's like the express terms of the contract, then their course of dealing, their course of business, and then trade custom.
So no one can see this poll that is up right now. Okay. So yeah, I like B. B is the correct answer because it's express term. Everyone agrees with B? Okay, yeah. B is correct. The party's new contract adopted the terms of the previous contract, which include a 15% fee. Okay, so we'll get right into it. I might not be able to use the poll today, so if you all just put your answers in the chat, you can put a direct message to me so not everyone else sees it if you don't want everyone to see it. But let's just go with that because I'm having trouble with the polling function today. All right, so we'll do torch questions. And we'll do 15 of them, and let's get to it. All right, here's the first one. And you can just put your answers in the chat. Just direct message me if you don't want everyone to see it. Okay. An ordinance in a small town required all restaurants to designate smoking and non-smoking sections for their customers. A cigarette smoker and a non-smoker were seated at adjoining tables in a small restaurant. The smoker's table was in the smoking section, and the non-smoker's table was in the non-smoking section. When the smoker lit a cigarette, the non-smoker politely requested that he not smoke, explaining that she had a severe allergy to the cigarette smoke. The smoker ignored the non-smoker's request and continued to smoke. As a result, the non-smoker was hospitalized with a severe allergic reaction to the smoke. The non-smoker brought a battery action against the smoker. Which of the following questions will not be an issue in the battery action? Did the smoker intend to cause the non-smoker's contact with the cigarette smoke? Does smoke have the physical properties necessary for making the kind of contact required for battery? Is contact with cigarette smoke from a lawful smoking section in a restaurant the kind of contact one must endure as a voluntary restaurant patron? Was the smoker's conduct unreasonable under the circumstances? So, yeah, Gabby's saying D, and everyone in the direct messages has been saying D. We like D here because it says what is not an issue. And the reason why it's not an issue here is because it's battery, and battery is an intentional tort. So let's go with D. D is correct. Whether the smoker's conduct was reasonable is irrelevant. The defendant's intent to cause harmful or offensive contact with the plaintiff is what would sustain a battery claim. Reasonableness would be relevant to determining negligence, not whether a battery occurred. So for our cram guide that we're continuing as a class, the first point that we can make is that battery is an intentional tort, and it is not relevant whether or not the conduct was reasonable. That kind of makes sense to me. Does that make sense to everyone? Okay. Oh, I can do the polls. The polling function is back on. See, you guys doubted me. No, I doubted myself. I'm just kidding. Oh, wait, that was from the NFL season. More doubt. All the doubt is deserved. All right, back to the polls. Let's go. See, everything works out just as we wanted it to. Share screen and let's continue. I'll try to keep the jokes at a minimum now and the learning at a maximum. A mother purchased over-the-counter pain medication for her daughter who suffered from headaches. The packaging indicated that the pills were coated, but did not list the ingredients in the coating. A few days after she bought the medication, because the daughter was in extreme pain, the mother gave the daughter 3 times the recommended dose of medication. 30 minutes later, because the daughter had a very rare allergy to an ingredient in the coating, she had a severe allergic reaction for which she was hospitalized. The mother was aware of the daughter's allergy, but did not know that the medication contained the ingredient to which the daughter was allergic. In a failure to warn action brought against the manufacturer of the medication, which of the arguments below would be the least promising as a defense? The daughter's allergy to the ingredient in the coating was very rare. The manufacturer's duty was to warn learned intermediaries, not consumers of the medication. The mother should not have given the daughter a triple dose of the medication. The mother, knowing of her daughter's very rare allergy, should not have purchased the medication without knowing what ingredients were in the coating. Take your time, everyone. You can read this one again. All right. Let's see. Did someone draw on my screen or did I do that? So you see the results. Everyone picked B. Does anyone explain to the class why it's B?
Because it doesn't matter like for who the label is for. Like for products like the medicine, if it has some kind of defect or something, all the products like that should have a warning label for everyone to read. Like it's supposed to be legible to read before you purchase the product or before you use it.
I agree. I agree with B because it's not true here. The manufacturer's duty was to warn learned intermediaries. What's a learned intermediary? Can anyone give me an example of a learned intermediary? Doctor, great job, Pablo. A doctor is a learned intermediary in the sense that a doctor will tell you if you should take this many dosages or whatever it may be. A doctor is the one who has a duty sometimes to give you a warning. But this one was over the counter, right? Over the counter. If it's over the counter medication, that's not a good argument right there. If anyone knows, by the way, if they put a yellow streak on my screen, if they could delete it, I don't feel like I didn't do that and I might be stuck with it forever. Yeah, the answer is B here. This question involves the sale of the use of over-the-counter medication, not prescribed medication. The learned intermediary doctrine insulates manufacturers from prescription drugs from liability if they provide adequate warnings to prescribing physicians, so has no applicable use in this case. Accordingly, the learned intermediary doctrine would be least effective support to the manufacturer in its defense of this action. See if that helped. All right, good. Sorry, I was like, I'm not gonna be able to teach with this little yellow streak. I have problems. Okay, so the learned intermediary rule applies to, let's say, doctors, for example, but does not apply for over-the-counter medications. Therefore, the defense that OTC medicine should be subject to the learned intermediary rule is a weak defense. Does that pretty much make sense to everyone? It's a good interpretation of it, that the learned intermediary rule is not going to apply to over-the-counter medication. Okay. Ooh, that's a good one. Let me add a new poll. Not for y'all, for me. This Zoom thing. I'm gonna go to Google Hangouts. Okay. A manufacturing plant emitted a faint noise even though the owner had installed state-of-the-art sound dampeners. The plant operated only on weekdays and only during daylight hours. A homeowner who lived near the plant worked a night shift and could not sleep when he arrived home because of the noise from the plant. The other residents in the area did not notice the noise. Does the homeowner have a viable nuisance claim against the owner of the plant? No, because the homeowner is unusually sensitive during the day. Oh, there's the poll's not launched right now, or it is launched?
It's launched.
Oh.
I have it on my computer.
Sorry. No, oh, someone sent me a direct message. Okay, no worries. A manufacturing plant emitted a faint noise even though the owner had installed state-of-the-art sound dampeners. The plant operated only on weekdays and only during daylight hours. A homeowner who lived near the plant worked a night shift and could not sleep when he arrived home because of the noise from the plant. The other residents of the area did not notice the noise. Does the homeowner have a viable nuisance claim against the owner of the plant? No, because the homeowner is unusually sensitive to noise during the day. No, because the plant operates only during the day. No, because the noise is heard beyond the boundaries of the plant. Yes, because the operation of the plant interferes with the homeowner's quiet use and enjoyment of the property. Oh, wow. So everyone picked A, like literally. We're just all geniuses in this class. So the answer is A, based on 100% uniformity. This is the most that anyone's ever agreed on anything in the history of people. A landowner is liable for nuisance only when his invasion of another's use and enjoyment is both substantial and unreasonable. The homeowner sleeps during the day and thus is unusually noise sensitive compared to others in the community. Because the homeowner is not experiencing the same level of disruption as an average person in the community, there's no private nuisance. So we can take that. There is no private nuisance claim when someone is unusually sensitive. For example, they are a nocturnal and kids are loud during the day. We're with that? I mean, we got 15 out of 15. Everyone got it right. 5 people abstained, but it's better than getting it wrong, I think. Okay, not on the MBE for the record. You have to answer every question. You do not get points for getting questions wrong. Jesus. Okay, let's do this. Number whatever. Next question. Ooh, nice and short. An 8-year-old went to the grocery store with her mother. An 8-year-old child went to the grocery store with her mother. The child pushed the grocery cart while her mother put items into it. The child's mother remained near the child at all times. Another customer in the store noticed the child pushing the cart in a manner that caused the customer no concern. A short time later, the cart the child was pushing struck the customer in the knee, inflicting serious injury. If the customer brings an action based on negligence against the grocery store, the store's best defense will be that a store owes no duty to its customers to control the use of its shopping carts. A store owes no duty to its customers to control the conduct of other customers. Any negligence of the store was not the proximate cause of the customer's injury. A supervised child pushing a cart does not pose an unreasonable risk to other customers. Does anyone out there have an 8-year-old child?
Granddaughter.
8-year-old granddaughter.
I am an 8-year-old child, if that helps.
I've kind of learned that. 9-year-old nephew. It's all right. 8-year-old child is good. Okay, so this poll. Let's end it. Most people are picking D, as in, don't you know, a supervised child pushing a cart does not pose an unreasonable risk to other customers. Right, so some people pick C and some people pick D. Can anyone explain why D is indeed the best answer?
I think it's when I was looking at the answer choices, like A and B are actually kind of true because you owe a duty to the customers to provide like a safe environment. So I feel like A and B are true and they're not the answers. And then C, it has the word any. And I remember any is like very skeptical, like answer choice. So any negligence of the store was not the proximate cause of the customer's injury. I mean, it could have been, but it doesn't, it's like too broad. So D is actually a true statement because if the child in the facts hasn't bothered the customer, then there's no like unreasonable risk to other customers. So he wasn't being like reckless and bumping into people on purpose.
I agree, yeah. I agree with the things that you're saying that create flashcard with paper clips. I agree with the things that you're saying that D's a better answer than C. Any negligence of the store was not the proximate cause of the customer's injury. That's accepting that they were negligent. D is just saying like we weren't negligent. Like there's a mom, 8-year-old kid was supervised. Like what did we do wrong? So D is pretty much a stronger answer. I would agree. The facts in this question present no basis for holding the grocery store liable, right? The answer states the fact in the language of negligence law. The store simply was not acting negligently because the child presented no risk. C is incorrect. It states a fairly weak defense. It was foreseeable that a young child pushing a grocery cart could cause injury to the other customers. If the other elements in the claim against the grocery store were met, the proximate cause would not alone be a strong defense for the store, right? So, C is not as good of an answer. Just so everyone knows that, you see when I highlight things, I don't know if you see it, it says create flashcards with paper clips. Paper clips is like a AI artificial intelligence app that creates flashcards for you out of things. So it's plugin that I have on my computer, but I put some of these paper clips flashcards in general for my outlines in the drive. But that's something cool that you can think of paper clips. It's an app that you can get that turns anything into flashcards. So, you know, the more tools you have, the better. I don't use it as much as I would like to, but I do think it is pretty cool. And by the way, you all did really well on that one. Okay, so let's do another poll. All right, beautiful. Hey, Lauren, can you see this poll? You can say yes in the chat. Okay. Yeah, it is cool, Erica. You're not old. AI is not new. AI, like when we were kids, we had Ask Jeeves, we had AOL Instant Messenger, and used to be able to ask little robots questions. And the whole trick was to get it to say inappropriate things, which seems to be the same thing they're doing today. Like AI is not new, it's just been refined. So don't be scared of technology. Technology is just old stuff getting better. Okay, let's do this question about spicy dinner. Spicy margaritas after this, right? A patron ate a spicy dinner at a restaurant on Sunday night. That was a joke. No spicy margaritas, spicy study sessions. A patron ate a spicy dinner at a restaurant on Sunday night. He enjoyed the food and noticed nothing unusual about the dinner. Later that evening, the patron had an upset stomach. He slept well through the night, went to work the next day, and ate 3 meals. His stomach discomfort persisted, and by Tuesday morning, he was too ill to go to work. Eventually, the patron consulted his doctor, who found that the patron was infected with a bacterium that can be contracted from contaminated food. Food can be contaminated when those who prepare it do not adequately wash their hands. The patron sued the restaurant for damages. He introduced testimony from a health department official that various health code violations had been found at the restaurant both before and after the patron's dinner, but that none of the restaurant's employees had signs of bacterial infection when they were tested 1 month after the incident. The restaurant's best argument in response to the patron's suit would be that no one else who ate at the restaurant on Sunday complained about stomach discomfort. The restaurant instructs its employees to wash their hands carefully and is not responsible if any employee fails to follow these instructions. The patron has failed to establish that the restaurant's food causes illness. The patron assumed the risk of an upset stomach by choosing to eat spicy food. Take your time with this one. All right. I'm very pleased with the amount of participation in the room. Almost everyone participated. That's very rare in an educational setting. So most people pick C. Does anyone, maybe someone we haven't heard from today, want to argue why they believe C is the correct answer? And Eric, I remember paper clips, that little dude who's that little paper clip on the corner of the computer and you used to click him and then he used to tell you stuff. That was artificial intelligence too, for the record. That little paper clip was the beginning of AI. C, the patron has failed to establish that the restaurant's food causes illness. What I would say here, and I have to actually go back and we need to document the last question too on our cram guide, but it's kind of similar to the last one, that like, no, they didn't breach a duty here, right? Not that they didn't breach a duty, but there's no causation. The last one was they didn't breach a duty. This one was there's no causation. These are just kind of going through the elements of negligence and being like, there has to be a duty, breach, causation, and damages. If you can't establish causation, then I don't think you have a very strong argument. A lot of people picked A. No one else who ate at the restaurant complained about stomach discomfort. Tempting answer, but it's just like, okay, so that is evidence that there wasn't causation, but C is just saying like overall that there wasn't causation. So I do feel like C is the strongest answer of the pack. C is correct. The defense has the best chance of prevailing. Have you noticed a trend of multiple questions today that have been like, what's the best defense? What if true? It's got like a little LSAT tinge to it. My other baby. Okay, so C is correct. The defense has the best chance of prevailing. Health code violations can only establish duty and breach. They do not establish the restaurant's causal, right? Everyone on the LSAT confuses that word with casual. Causal control over the specific instrumentality that caused the actual food poisoning. In addition, res ipsa loquitur does not apply because the patron was unable to show that the restaurant had exclusive control over everything he ate within the period leading up to his illness. As a consequence, the restaurant's negligence cannot be inferred by the circumstance. A is incorrect. This is an ineffective defense because it may not include anyone who is not aware of why they might have been ill. The best defense is to show that the patron has not established causation, right? It's like, yeah, just because you didn't cause it with anyone else doesn't mean you caused it with me. C is a better answer. So let's go back to the cram guide. The first point that we took was a store owner will not be liable for negligence, or at least has a strong argument against negligence. If an 8-year-old supervised kid who has shown no risk pushes a cart into another customer, right? Sounds to me like this kid's going down for battery. This kid's a young puff daddy. Okay, and then here we would say that if someone gets sick, the person must prove that the restaurant caused the illness. It will not merely be inferred. So this one was duty, this one was causation. Remember when I did my PowerPoint, if anyone's paying attention, I said 50% of MBE torts questions are actually negligence. So that's ringing true today. All right, let's try this one. And by this one, I mean this one. An 11-year-old, look at these kids, man. Kids ain't all right. I was listening to these kids the other day. I was like, I like a Chipotle or something, and there was like a group of kids, and I was like, couldn't help. And I was like, ah, man, these kids, they're still the same pieces of shit kids as back in my day. Everything you heard about it wasn't true, but maybe it was just the wrong group of kids. Okay. An 11-year-old boy was driving a full-size motorcycle on a private road where the boy was a trespasser. The motorcycle hit a tire that had fallen off a truck driven by a delivery company employee who was making delivery to an address on the private road. The boy was injured when his motorcycle went out of control after striking the tire. In a negligence action brought on behalf of the boy against the delivery company, the company contends that the boy was contributory negligent and that his damages, if any, should be reduced in conformance with the jurisdiction's comparative negligence statute. The boy argues that his conduct should be judged according to the standard of a reasonable child of like age, intelligence, and experience under the circumstances. Is the boy entitled to be judged according to the standard of care that he has argued for? No, because the boy was driving a motorcycle. No, because the boy was trespassing on the private road. Yes, because comparative negligence applies, or yes, because the boy was 11 years old at the time. So the question is, should he be judged according to this standard, a reasonable child of like age and intelligence? But the fact pattern does say that he was driving a full-size motorcycle. So I think that's why the majority of class is leaning towards A, because he's doing an adult-like activity. This is, day one, chapter 1, torts, kids driving a motorcycle. He's going to be held to an adult-like standard of care. If a kid is driving a motorcycle, he will be held to an adult-like standard of care. All right, we're doing fantastic so far. No problems, only solutions. Hey, Lauren, can you see this poll? Hey, you're having issues with the poll. I'm not trying to pick on you. I'm just like wondering. Okay, so the motorist, the Rapido, the R is a sports car manufactured by the R Motor Company. The R has an excellent reputation for mechanical reliability, with one exception. The motor may stall if the engine has not an extended warm-up. If the engine has not had an extended warm-up. A driver had just begun to drive her R in city traffic without a warm-up when the engine suddenly stalled. A car driven by a motorist rear-ended the driver's car. The driver suffered no external physical injuries as a result of the collision. However, the shock of the crash caused her to suffer a severe heart attack. The driver brought an action against the R Motor Company based on strict liability and tort. During the trial, the plaintiff presented evidence of an alternative engine design of equal cost that would eliminate the stalling problem without impairing the functions of the engine in any way. The defendant moves for a directed verdict at the close of the evidence. The motion should be denied because the jury could find that an unreasonably dangerous defect in the engine was a proximate cause of the collision. Denied because the jury could find that the R was not crashworthy. Granted because the motorist's failure to stop within assured clear distance was a superseding cause of the collision. Or granted because a person of normal sensitivity would have suffered a heart attack under these circumstances, would not have suffered a heart attack under these circumstances. So, Lauren, you might be, are you on an iPad? Because Noelle's saying she can't see it after the question comes up, it disappears, but she's on an iPad. Okay, no. So maybe you two are doing something that you two, Noelle and Lauren, maybe you guys can message each other back and problem solve. All right, so we have unanimity in A, right? It was unreasonably dangerous defect. And the reason we like that is because this is a defective design case. This is a strict liability case. This is what you would need. Because the sports car performed exactly as it's designed to perform, this is a defective design case. The driver provided evidence that an alternative engine of equal cost and performance was possible without the stalling flaw. Under the facts, the judge could find that the driver met her burden to show injury to herself as the result of a design flaw that was not technologically and economically burdensome for ours company to correct. So pretty easy takeaway here.
Andrew, what does crashworthy mean?
Can survive a crash. Like if you ever see those, tests where like the car goes into the wall with a dummy, like that's a crashworthy test. So they were saying that because it wasn't crashworthy, they wouldn't prevail. But it wasn't about it being crashworthy or not. It was more about it being a defective design. That's the, what they were pinpointing. I mean, it's true that maybe it wasn't crashworthy, but it's irrelevant. It's about the design flaw. Okay. So a design defect occurs if a product is unreasonably dangerous, especially if there is evidence of an alternative design, an alternative safer design at the same price. Like they gave us a lot of facts here to be like, this thing was defectively designed. You could have done it without stalling for the same price. If it was like $1 million more to do it, maybe it wasn't defective, but this was very defective. Let's see, should we do this one? Why not? I mean, I know why not, it's kind of long, but whatever. Okay. After a car buyer failed to make timely payments to her auto loan and failed to respond to notices of default properly sent to her home address, the loan company hired a collection agency to repossess the car. An employee of the agency went to the buyer's home and knocked on the front door. When the buyer answered, the employee explained that he was there to repossess the car and ask for the car keys. The buyer handed the employee the keys, but then asked the employee to allow her to retrieve her laptop computer from the car. The employee declined this request, explaining to the buyer that any possessions of the car could be reclaimed from the company after the car was repossessed. After pleading unsuccessfully with the employee, the buyer shoved the employee away from the door with such force that the employee fell and suffered a broken wrist. The buyer then ran to the car, which was unlocked, and retrieved the laptop. The employer has sued the buyer for battery. The buyer has moved for summary judgment, arguing that she was privileged to act as she did. Should the trial court grant the buyer's motion? No, because a fact finder can reasonably conclude that the buyer used excessive force in attempting to defend her property. No, because the buyer handed the keys to the employee, the car was no longer her property. After the buyer handed the keys to the employee, the car was no longer her property. Yes, because a possessor can use non-lethal force to protect his or her property. Yes, because the buyer complied with the law by returning the car keys and acted reasonably in asking to retrieve the laptop. So we got a situation. Hey, I want to get my laptop from the car. Sorry, ma'am, you can't do that. Wow, get out of my way. Seems kind of potentially problematic. But I agree with the class here. I think it's A. They could reasonably conclude that they use excessive force. Like this could be a really true policy. Like, hey, you got your car repossessed. You can't get the laptop. Like you can't just push someone. I mean, maybe you can, maybe you can't. I would say you can't here. I would think they're going to go down for battery. Some B's and C's, the car was no longer her property. That's not the case. Just, I mean, even so, even if the car was no longer her property, that doesn't mean that it justifies battery. Like you can't just batter people because, you know, I mean, well, no, B is saying no, that it was her property, but that's not why. That's not why, that you should win for battery. Because even if it wasn't her property, that's irrelevant. The question is whether or not it was excessive force. So let's see. Yeah. Summary judgment will be granted if a party shows there's no genuine dispute of material fact and the party is entitled to judgment as a matter of law. The buyer intentionally shoved the employee, which satisfies prima facie case for battery. As an affirmative defense, the buyer could claim that she was privileged to use force against the employee in order to maintain possession of her property. However, this defense will be established only if the jury reasonably concludes that the buyer's use of force was reasonable, not excessive under the circumstances. See, that's where I say the word reasonable does come into play with battery, but not for the element of battery, for battery as a defense. Thus, the trial should deny the buyer's motion for summary judgment because there is the dispute as to whether the buyer's use of force was reasonable. So if a lady pushes a man who has repossessed his car and the push, the court should not grant summary judgment saying there is no battery because she may have used intentional force that was not reasonably privileged, right? Like maybe it was reasonably privileged, but this is summary judgment. There's got to be a disputed material fact. Let's let the jury decide if this woman should have pushed this man or not. In general, or anti-battery, no touching. Okay, unless it's the sweet sport. I'm gonna find my next poll. Well, maybe everyone can put this one in the chat while I try to find the poll. I don't know why I'm having an issue right now. So a food company contracted with a delivery service to supply food to remote areas around the world. The contract between the food company and the delivery service were terminable at will. It was terminable at will. The delivery service then entered into a contract with an airline to provide an airplane to deliver the food. So let's look at what we have right here, because we're having a tortious interference question. So you got to know who are the parties. So the first party is a food company contracted with a delivery service. Then we have the delivery service was with the airline. Okay. Also terminable at will. The food company was displeased with the airline because of a previous business dispute between them. Upon learning of the delivery services contract with the airline, the food company terminated its contract with the delivery service in order to cause the airline to lose its business. After the food company terminated the delivery services contract, the delivery service had no choice but to terminate the airline contract. The airline sues the delivery service for tortious interference with contract. Will the airline prevail? No, because the airline delivery service were parties to the contract. No, because the airline was not in privity with the food company. Yes, because the delivery service did not terminate the contract because of poor performance. Yes, because the delivery service's termination of the contract made it a party to the food company's acts. So a lot of people are picking A. Does anyone want to explain to the class why they think A is the correct answer?
I can explain. So the initial contract is between the food company and the delivery service, and then a separate contract is the delivery service with the airline. So if the airline sues the delivery service, they have their own contract that has nothing to do with the contract between the food company and the delivery service. For them to prevail under the tortious interference with the contract, the airline was supposed to sue the food company directly because they had technically tortiously interfered with the agreement between the delivery service and the airline. So it was the wrong standing. They sued the wrong party for that cause of action.
Exactly. And everyone wait till the next question to click and answer for this poll, or definitely don't for that one person. Sorry, children. Okay, don't click this yet, please. So, yes, I agree with what Erica said right there, that this is not tortious interference because you need to interfere with another contract. All you did right here was terminate your own contract, and then the result was that they rescinded their contract, but you didn't interfere with a third-party contract. You only rescinded your contract. Okay, so A is correct. The airline company sued the delivery service based on a theory of the tortious interference with its contract. The tort of interference with contract provides a cause of action against those who improperly interfere with the performance of a contract between the plaintiff and a third person. In this case, the airline and the delivery service were parties to a contract, and any action between them would be based on the contract, rather than on tort, right? Maybe they breached the contract, but there wasn't an actual tort here. The proper defendant in the tort action would be the food company. So, tortious interference, aka intentional interference with a business relation, must be interference with a third party contract. Let's make that more clear. With a contract between two other parties, not your own contract, right? So I always give this example of tortious interference. Like there's this one university that loves telling their students not to work with me because, I don't know, we just get too good of results. And I'm always like, that's tortious interference. You interfering with my contract between my student, that's tortious interference, right? It's another entity interfering with a contract between two other parties. It's not, oh, we're going to break up this contract with you, student, if you work with them. That would be a different example. It has to be a party interfering with a third party. All right, excellent. Let's do a few more. So a nice short one. Here we go. Now we can use the polling function. The governor of a state signed a death warrant for a convicted murderer. Two protesters are active opponents of the death penalty. At a demonstration protesting the execution of the murderer, the protesters carried large signs that stated, "The governor, murderer." A television station broadcasted news coverage of the demonstration, including pictures of the signs carried by the protesters. If the governor asserts against the television station a claim of damages for intentional infliction of emotional distress, will the governor prevail? Yes, because the broadcast showing the signs caused the governor to suffer severe emotional distress. Yes, because the assertion on the signs was extreme and outrageous. No, because the governor did not suffer physical harm as a consequence of the emotional stress caused by the signs. Or no, because the television station did not publish a false statement of fact with actual malice. Yeah, they do. There's this question is this fact pattern is used for a different question. There's multiple instances of that on these Q banks where they have the same fact pattern but different questions. So don't be mindlessly just picking C because you've seen it before. Like read it and make sure it's the same question. It was a pretty big split here. The one you guys are talking about is where they say the only reasonable interpretation of the claim that he was a murderer is that he signed a death warrant, which he did do. Therefore, in that example, there's no defamation claim because truth is an absolute defense to defamation. This is an example where they're talking about the television station, not the protesters themselves. So we have a pretty big split here. This will be fun. Let's see. Does anyone, and maybe someone who hasn't been so vocal, but anyone want to talk about why they think either D or C is the correct answer?
Okay, so I ruled out C, and sorry, if anyone else wants to talk, you're welcome to cut me
There you
off.
go. Go ahead.
I ruled out C because I don't know if that's in the fact pattern that the government, it's possible like the government started having nightmares and it hurt his head or whatever. But I ruled out C because I don't think that's in the fact pattern. D, I think is more relevant to no, this is IIED. I don't know if actual malice is relevant to that.
Right. I think they didn't publish a statement. They just broadcast the news. This is, public. It's what the news people do, So I'll go with D here as well. To prevail on a claim for IID, a plaintiff is required to prove that the defendant engaged in extreme or outrageous conduct with intent to cause severe emotional distress. Merely broadcasting news coverage is not IID because there's no actual malice. So it's a pretty easy takeaway that merely broadcasting news coverage is not IIED because there is no outrageous behavior.
Andrew, the flashcards that you mentioned about like purchasing and reviewing, I reviewed the flashcards for Torts yesterday, and it actually said like for like a public figure, it included like a governor or like some government authority. So that's what helped me recognize the answer choice for D here.
That's a good point too, right?
Yeah.
Well,
So you have to like for defamation, you have to kind of see like the standard is malice.
To be fair, that's the other way they test this question. This one they weren't asking about defamation, they're asking about IIED. And they're saying it's not IIED because it wasn't malicious. The other one was asking about defamation, right? This one was just asking about IIED.
Oh, yeah.
Yeah, but seems pretty similar. Okay. All right, let's talk about 9 drinks. A plaintiff and his men were passengers sitting in adjoining seats on a flight on an airline. There were many empty seats on the aircraft. During the flight, a flight attendant served the man 9 drinks. As the man became more and more obviously intoxicated and attempted to engage the plaintiff in a conversation, the plaintiff chose to ignore the man. This angered the man, who suddenly struck the plaintiff in the face, giving her a black eye. If the plaintiff asserts a claim for damages against the airline based on battery, she will prevail because she suffered. So it's the plaintiff versus the airline. But actually, who did it? The man, he struck him. So going against the airline is a little bit excessive here, I think. Prevail because she suffered intentionally inflicted harmful offensive contact. Prevail because the flight attendant acted recklessly in continuing to serve liquor to the man. Not prevail because the man was not acting as an agent or employee of the airline. Or not prevail because she cannot establish some permanent injury from the contact. There you go. Someone said you got this question the other day. And trust me, I've gotten all these questions before. There's only 1,600 questions or so in the Q bank. And honestly, I know it sounds daunting, but you can do them all many times. That's what Julian would do. So let's see how the results are looking. Most people are picking C here, right? That it wasn't the man, it wasn't the airline, it was the man who's the one who did the tortious act. For the airline to be held responsible for a man's commission of battery against a plaintiff, vicarious liability must apply. There's no evidence of a special relationship between the man and the airline, such as being an agent or employee. As such, vicarious liability will not attach. So,
Hey, Andrew,
yeah,
what about common carrier? Doesn't the airline have a responsibility to ensure that the other passengers aren't intoxicated?
absolutely. But that wouldn't be a claim on battery. That would be a negligence claim.
Ah, got it.
Yeah, that's a breach of a duty, but here it's battery. So there can be no vicarious liability to justify battery on behalf of a man for an airline if the man is merely a passenger. Usually there's not even vicarious liability for intentional torts if they're an employee. There would only be if it's inherent to the job itself, like being a bouncer at a club. That's kind of like a, violent job, I guess. Sorry, give me 1 second. Okay, good job, everyone. So, perfect. All right. A well-known movie star was drinking vineyard wine at a nightclub. A bottle of the vineyard wine, with its label plainly showing, was on the table in front of the actor. An amateur photographer asked the doctor if he could take his picture, and the actor said yes. Subsequently, the photographer sold the photo to a vineyard. Vineyard, without the actor's consent, used the photo in a wine advertisement in a nationally circulated magazine. The caption below the photo stated that the actor enjoys his vineyard wine. If the actor sues Vineyard to recover damages as a result of Vineyard's use of the photography, will the actor prevail? No, because the actor consented to being photographed. No, because the actor is a public figure. Yes, because Vineyard made commercial use of the photograph. Or yes, unless the actor did, in fact, enjoy the vineyard wine. So here, I always tell people this when it comes to torts, and Rob, thank you so much for that misguided question you asked the last time, because it helps us answer, it helps us clarify something. You have to be in tune to the cause of action. Here, the cause of action is for misappropriation, right? It has to be misappropriation for the use of the photograph. The last one, the cause of action was for battery. That's why we didn't do the common carrier, negligence, whatever that piece is. Here, as 13 out of 13, or however many people have decided, it's the same thing. The cause of action here is going to be misappropriation, and C points us to the misappropriation answer, right? Commercial appropriation, well, misappropriation or appropriation, of the actor's likeness for Vineyard's benefit is subject to damages in a claim for invasion of privacy. The actor, as a well-known movie star, has a property right in his name and likeness. Vineyard cannot use the photograph without being granted a license to do so by the actor. So, using a famous, let's just say a person, using a person's likeness for commercial purposes is, sorry, appropriation is a privacy tort. Right, it's pretty simple. Everyone in the class got that right? Okay. Wait, that one doesn't work. All right. think we just have a couple more, so bear with us. So a trucker driving down an isolated country road late one night. Oh, I think this one has two answers. I have a feeling this one has two answers. Okay. A trucker driving down an isolated country road late one night struck cattle that had escaped from a farmer's pen and wandered into the road. The trucker was unable to stop before hitting the cattle, but was not driving carelessly. While he was not injured in the collision, the trucker sustained damage to his truck and lost income during the time it took to repair the truck. The trucker sued the farmer for his damages and invoked the doctrine of res ipsa loquitur. At trial, the farmer introduced evidence that his cattle pen was of sufficient height to prevent cattle from stepping over it and was constructed of thick steel pipe sitting in concrete with a substantial top rail. A sturdy pen such as this one would be more difficult for cattle to break through than one constructed of barbed wire or electric wire. Should the trial court allow the case to go to jury with the res ipsa loquitur instruction? No, because it's possible that a third party wrongfully let the cattle out of the pen. No, because the trucker must submit direct evidence of negligence in order to invoke the res ipsa loquitur doctrine. Yes, because the farmer is strictly liable for harm caused by escaping cattle. Yes, because the jury could conclude that cattle would not ordinarily escape a strong, secure cattle pen in the absence of negligence. Cool. So, overwhelming majority of people here are picking D. It just seems like how else would it have got there in the absence of negligence? I think this one may have two answers though. Oh no, that's a different question. All right, this has one answer. The facts indicate that the farmer was in exclusive control of his farm and that the trucker did not contribute to the accident. Therefore, the jury is permitted to conclude that the cattle escaped through the farmer's negligence. C is incorrect. If an accident is caused by a motorist colliding with livestock on a public roadway, there's no trespass to land and therefore no strict liability claim. Generally, a defendant who is responsible for a farm animal that strays onto a public roadway is liable for negligence only. So it's pretty straightforward. A farmer whose livestock wanders onto a highway and causes injury is likely liable for negligence, possibly under res ipsa. You see, I've had a lifelong struggle with these polls. Okay. So the owner of a shopping mall, we all got to get this one right, hired a construction company to design and construct a new entryway to the mall. The construction company negligently selected an unusually slippery material for the floor covering. A week after the entry was completed, a customer who had come to the mall to buy cosmetics slipped on the floor of the entryway, sustaining injuries. The customer sued the mall owner for the construction company's negligent design of the mall's entryway. Will the injured customer be likely to recover damages? No, because the construction company will likely be considered an independent contractor. No, because other customers had previously slipped on the floor. Yes, because the customer intended to make a purchase at the mall. Yes, because the mall's duty to maintain safe conditions was non-delegable. Right, we all know that the mall has a non-delegable duty to maintain a safe premises. Excellent. We can put that right in the cram guide. The mall has a non-delegable duty to maintain a safe premises. A dentist was anesthetizing a patient's jaw before pulling a tooth. Although the dentist used due care, the hypodermic needle broke off in the patient's gum tissue, causing injury. The needle broke because of a manufacturing defect that the dentist could not have detected. Is the patient likely to recover in action against the dentist based on strict liability and malpractice? No, on neither basis. Yes, based on malpractice, but not on strict product liability. Yes, based on strict product liability, but not on malpractice, or yes on both issues. So this one I'll kind of walk people through. We seem to mostly be getting it right. But the point here is that the dentist was using the product, right? The needle broke off while the dentist was using it. So how, and the dentist could not have detected it, and he was using due care. The dentist did nothing wrong here. If anyone can sue, can recover on strict product liability, it would be the manufacturer of the needle, and there's no evidence of malpractice here. So strict product liability will fail because the dentist is not a commercial supplier of the needle, he's a foreseeable user of the needle, and they'll fail on malpractice because it says straight up he used due care. So the answer here, as most of the class chose, will be neither. So we can take away a dentist is a user of a needle, not a supplier. Therefore, if it breaks during surgery, the customer cannot sue the dentist for strict liability. And a dentist is not liable for malpractice if he exercised due care. Right? Like if he didn't do anything wrong, then how could he go down for malpractice? And how could you go down for strict liability if you did nothing wrong? So, another great session, 15 questions that we did. I think we took away some key pieces. Again, I'll continue to, clean up this cram guide that we made, make it a little bit neater for everyone to take from. But you can see as a class, we've done a really good job so far with coming up with a contracts cram guide. And now we're on our way with our torts cram guide. We got some key points. And I just want everyone to continue doing this because as Julian will tell you, as I will tell you, as anyone who's passed the MBE will tell you, this is the most effective way to study, to do practice questions and then to document the little lessons that you learn from each question. So as always, I want to thank everyone so much for joining me today. I hope you all have an amazing rest of your day.